Good day everyone and welcome to Simone Legal. This is a very important video whether you've been asked to be the successor trustee of someone else's trust, or you're creating a trust for your family or business, or you've been suddenly and unexpectedly thrust into the role of being the new trustee after the last living trust grantor has passed away. I will give you the information you need to know in this video. So, first off, what is a successor trustee? If you aren't familiar with trusts and how they operate, you probably wouldn't understand the answer to that question because a successor trustee is possibly the trickiest position to understand in the world of trusts. So let's start at the beginning by asking, what is a trust? A trust is a legal entity that, like a corporation, LLC, or partnership, must have certain elements. I like to compare a trust to a legal entity that you are probably more familiar with, the corporation. So the trustee of the trust is like the CEO of the corporation, the person who runs the show and everyone answers to. The buck stops with a trustee. A grantor of the trust is like a founder of the corporation, one who contributes their assets to create the trust. Now, the beneficiaries of the trust are like the stockholders of the corporation. They benefit when the trust has positive cash flow. So, a trust is a fiduciary arrangement where the trustee holds title to the trust assets for the benefit of the beneficiaries. These assets are held and managed by the trustee until they can be distributed at the end of the trust administration process. As I mentioned earlier, a person who creates the trust in the first place is called the grantor, and when the trust is created, designate a successor trustee to manage the trust after they pass away or become incapacitated. Now, if they're smart, they will also designate a backup successor trustee or two in case the first successor trustee is unable to act. By the way, many people ask me about the role of the executor. I'm happy to get this information out now because many are confused by it. The answer is actually quite simple. There is no executor in a trust. An executor is the person who is nominated in a will to handle the estate of the deceased. The executor is like the successor trustee or CEO, as we were saying, and the estate is like the assets of the corporation or trust. Discussing wills is a whole other story that I won't get into now, but I want to make sure that everybody knows that if an estate's assets include real property or over $184,500 in California as of 2024, then the executor will be required to hire a probate attorney and open a probate case. That's the main reason that Simone Legal PC is drafting living trusts every week, almost every day. Probate is a miserable process for the family and especially the executor that takes place for 8 to 24 months in a public courtroom before a judge with many hearings, valuations, accountings, reports, etc. And in the end, the judge decides who gets what, and yes, this is all in the public record. The happiest person at the end of the probate is the attorney who walks away with a nice chunk of the decedent's estate. Now, getting back to trusts. There are many types of trusts, but the two main categories are revocable trusts and irrevocable trusts, each governed by a different set of rules. We'll discuss both types later, but for now you should know that the vast majority of trusts are revocable living trusts. The legal term revocable means that the trust can be modified or even terminated or revoked by the trustee or trustees at any time. Living is not a legal term, but a marketing term that was created to show that the terms of the trust are living, as they can be updated at any time, and also the fact that a complete estate plan does have many features such as a springing power of attorney and advanced healthcare directive that benefit the grantor's trustees while they are still living. How does a trust work after someone dies? Well, quite simple in theory, but difficult in real life. The moment that the trustee passes away, the first successor trustee instantly becomes the new trustee by operation of law. So if you've been named the successor trustee, you'll need to understand your responsibilities, so you might as well start now. If you're a trust beneficiary, it's also important to learn about the process of administering a living trust after death because you're going to want to monitor it. If you're the successor trustee of an irrevocable trust, you'll need to grasp how settling it differs from handling a revocable trust. So, if you are a successor trustee or someone about to designate your successor trustee, this is critical information to know. By the way, beneficiaries also need to monitor the trust administration process to hold the trustees accountable. Now, the California Probate Code requires trustees who are managing a trust after the death of the grantors to perform certain tasks. Managing a trust after death can be challenging, and chances are you will not have much, if any, warning. So prepare yourself now. Fortunately for you, you can use this video as a helpful guide to administer and close a revocable or irrevocable trust after the death of the last living grantor trustee. How does a living trust work after death? A revocable living trust is a type of trust that the grantor can modify, amend, or terminate, revoke, during their lifetime. However, in California, after the last living grantor's death or incapacitation, the trust usually becomes fully irrevocable, meaning that the successor trustee must follow its terms exactly as set forth by the grantor's trustors. Grantors are trustors, same term. Many people choose revocable living trusts for their estate plans because of the flexibility they offer. For instance, a single childless person would prefer a revocable living trust so that they can amend it if they get married or have children in the future. If you want to learn more about a revocable living trust, make sure to watch my video or read the blog article entitled The 10 Benefits of Living Trusts. I'm sure you'll be amazed at how many huge benefits a solid estate plan has for you and your family. But don't confuse estate planning and personal medical benefits with asset protection. It's important to note that revocable trusts generally do not provide significant tax savings, asset protection, protect assets from creditors. But fear not, Simone Legal PC has solved that problem with the Peace of Mind package, where we custom tailor a California LLC and living trust arrangement that provides asset protection and estate planning together for one low price. Check out the video or article entitled The Best of Both Worlds Using LLCs and Trusts Together. So how does an irrevocable trust work after death? An irrevocable trust is a type of trust that, once created, essentially cannot be altered or revoked by the grantor. Once the grantor executes an irrevocable trust, they lose control over its assets, and the trustee must strictly follow the trust terms as originally set. Well, wait a minute, you say. Why would I want to place my assets into something that I have no control over? And if I don't like it, I'm stuck with it? Well, to oversimplify it, we'll start out with a definition of ownership. For example, I own my home because I can sell it, can take out loans on it, I can rent it out, I can paint it hot pink if I like, etc., etc. In short, I have control over it. If I place that property into an irrevocable trust, aside from the terms that I set forth in the beginning, I no longer have control over it. The trustee does, under the terms of the trust, which can't be changed. Now, since grantors have no control over the assets in an irrevocable trust, these trusts are treated as separate tax entities. This means the assets within the trust are not included in the grantor's taxable estate, potentially resulting in huge tax savings. Additionally, creditors find it difficult to access the assets in an irrevocable trust to satisfy the grantor's debts, as these assets are no longer legally owned by the grantor. One irrevocable trust that I like a lot is called the Charitable Remainder Trust, or CRT, which is most often used by wealthy grantors. It provides substantial tax advantages to the grantors and beneficiaries with a specific format that pays the grantor a regular income during their lifetimes and then contributes the remainder to a designated charity or charities. It's a brilliant win-win-win scheme which benefits the grantors, beneficiaries, and of course the charities. Now, assets must be transferred into a trust. This is an important point. Getting back to estate planning basics, with a will, assets are generally considered to be part of the estate if they are not held by a trust or transferred through other non-probate methods, such as joint tenancy or beneficiary designations. On the other hand, for an asset to be part of a trust and thus avoid probate, the title of real property must be transferred into the trust's name by grant or quitclaim deed, must be recorded, and there must be language that personal property is to be distributed under the direction of the trustee. This funding of the trust is critically important, and we at Simone Legal PC constantly remind our clients to get that deed to trust notarized and recorded. If that is not done, then there will need to be a probate case opened, even though there's a trust, and that would be sad. Trusts are not subject to probate. Probate is a court-supervised proceeding that involves appointing an executor or administrator and validating the decedent's will, if there is one. Estates typically go through probate, while trusts should not. One of the main advantages of trusts is that they avoid probate, which can be complex, expensive, and time-consuming. Additionally, probate often requires the executor or administrator to get court approval before making distributions to beneficiaries, and sometimes the judge decides who gets what. Takes a long time, costs a lot of money, so don't do it. Do the trust. Now, how to close a trust after death. As the successor trustee of a trust, your role is to settle the trust, which means you must eventually wind it up by distributing its assets according to the trust's terms. While many trusts are fully distributed shortly after the grantor's death, some are designed to remain open for extended periods. For example, if a grantor sets up a trust for their minor children, California law requires that the children cannot access their inheritances until they reach adulthood, the age of 18. As a result, the trustee may need to keep the trust active for several years to ensure the grantor's wishes are fulfilled. Similarly, if a grantor is concerned that their adult children might misuse their inheritance, they might set up the trust to make gradual distributions over time rather than a lump sum. Some trusts might even include conditions for beneficiaries like completing college before they can claim their inheritance. Now, settling a trust can vary greatly depending on its terms. It's vital for new trustees to follow the trust provisions precisely to avoid potential breach of trust claims by beneficiaries. If you find interpreting the terms challenging, it's wise to consult a probate attorney before proceeding further. Something to remember, estate planning attorneys primarily deal with the events while the grantors are still alive, while most post-death issues are handled by probate attorneys, even if there is no probate in case to be filed. All right, steps for managing a trust after death. If you're unsure about what to do with a trust after someone's death, you're not alone. The process of administering a trust can be complex, but following each step carefully and in the correct order will simplify your task. Having a trust administration attorney, like I said, a probate attorney, can make a significant difference in protecting you from potential liabilities as a successor trustee. If a beneficiary feels wronged and files a court case and the court determines that you breached your duties during the administration, you could face substantial financial penalties. Therefore, having a lawyer on your side is a prudent measure for every trustee who is administering a complex trust estate. Additionally, the cost of legal services can often be covered by the trust assets, so there's generally no reason not to seek professional assistance if you have become the trustee after the death of the grantors. Now, locate and review relevant documents. Your first task after learning that a grantor has died or become legally incapacitated is to gather the essential documents. This typically includes certified copies of the grantor's death certificate from the coroner's office, the trust instrument, and any other relevant estate planning documents, such as an advanced healthcare directive or power of attorney. The grantor may have previously informed you of the trust's location, but if not, you might need to search through their office or personal files. If you cannot find the trust instrument, check with the grantor's family and friends to see if they know where it might be. If it remains missing, trust administration cannot proceed. The assets may need to go through probate and be distributed according to intestacy laws, unless there's a will specifying alternative distribution. So trustors, grantors, make sure everybody knows who your trust is. Now, before moving forward, you'll need to interpret the trust instrument. This process can sometimes be straightforward, but there may be ambiguities or issues that require assistance from a lawyer or potentially the court. Ensure that you fully understand the trust instrument and its terms before proceeding to the next step. Provide notice to beneficiaries and heirs about trust administration. Under California Probate Code Section 16061.7, trustees must provide written notice to trust beneficiaries and the grantor's heirs about the commencement of trust administration. This notice must be given within 60 days of the grantor's death or 60 days from when the trustee takes over, whichever is later. For notification by trustee to be valid, it should contain all of the following information: the name of the grantor and the date the trust was signed by them, the name, address, and phone number of each trustee of the trust, the address where trust administration will take place, any additional information required by the terms of the trust, a notice that the recipient may request from the trustee and be provided a complete copy of the trust, A notice that the recipient has 120 days from the date they received notice or 60 days after a copy of the trust is mailed or delivered to them, whichever is later, to bring legal action to dispute the trust. If the trustee's notification is invalid, delayed, or if a copy of the trust is not provided to beneficiaries or heirs promptly upon request, it can lead to delays in administration and potential accusations of duty breaches against the trustee. And maybe you'll get sued. Gather and value trust assets. After completing the initial steps of trust administration, your next task is to create an inventory of the trust assets. Start by gathering the assets listed in the trust document. Organize these assets into a spreadsheet to track their entry and exit from the trust, their value at the time of the grantor's death, and any changes in value over time. For liquid assets like bank accounts, list their value as of the grantor's death. For non-liquid or fluctuating assets such as real estate, stocks, or bonds, you may need to hire a third-party appraiser or a probate referee. That's a neutral state-appointed appraiser who is usually more cost-effective. It's wise to avoid valuing assets yourself, as this could be perceived as a breach of trust and lead to disputes with beneficiaries. Keep your inventory updated and maintain detailed records of all transactions. This will make trust accounting more efficient and provide a clear record if beneficiaries request justification for your actions. Satisfy the grantor's debts. Before distributing trust funds to beneficiaries, you must first settle the grantor's valid creditor claims. Typically, if the grantor's estate has enough assets, it will cover these debts. However, if the estate's assets are insufficient, creditors might be able to claim from the trust, especially if the trust was revocable at its creation. As the trustee now, failing to address all outstanding debts before making distributions could make you personally liable for these debts. So remember, government agencies are considered creditors too. So ensure all tax obligations for both the grantor and the trust are met. Consulting a CPA can be invaluable for preparing tax returns and managing these obligations. Prudently manage and invest trust assets. Depending on the trust terms, the trustee may need to make prudent investments to generate income for the trust. For instance, they might choose to invest some of the trust's liquid assets in stable, dividend-paying stocks. Conversely, investing in a high-risk business that may not yield profits for years could be considered imprudent. Trustees should also avoid leaving assets that could be generating income idle. For example, if the trust owns a vacant property, renting it out or selling it might be a better option than just letting it be vacant. Trustees can be held liable for poor investment choices or selling property below market value. However, they may be able to defend against breach of trust claims if they can demonstrate that their decisions were reasonable and well supported, even if the outcomes were less favorable for the trust. Track down title to trust assets. To effectively manage trust assets, it's essential to ensure that they are properly titled in the name of the trust. Sometimes assets are already titled correctly, and the trustee simply needs to update the trustee's name on those assets. These could involve recording new documents for real estate or submitting formal paperwork to financial institutions for liquid assets. If the assets are not yet titled in the name of the trust, the trustee may need to file an 850 petition with a probate court to officially transfer the title. This 850 process helps to align the asset's title with the trust requirements. Account to beneficiaries and heirs. As previously mentioned, trustees must monitor any changes in the trust's value and keep track of all assets entering and leaving the trust. Trustees are required to provide beneficiaries with a formal accounting each year while the trust remains open. Beneficiaries also have the right to request reasonable financial information related to their interests at any time. To manage these responsibilities effectively, trustees should be thorough and organized. Using trust accounting software, maintaining a filing system, and employing other organizational tools can be very beneficial. Since the costs of professional service can typically be covered by the trust, it is advisable for trustees to have a CPA or probate attorney review their accountings for accuracy, or even prepare them entirely. Make distributions to beneficiaries in accordance with the terms of the trust. Trusts may specify that distributions to beneficiaries be made either as a lump sum or over time. It's crucial for you as the trustee to understand the trust terms to ensure you distribute the assets accordingly. Trustees should also be attentive to making distributions promptly. Once trust administration is complete, distributions should follow shortly thereafter. Unlike executors or administrators, who are generally required to distribute assets without delay, trustees often have more discretion regarding when to make distributions. For instance, trustees may be permitted to withhold a distribution temporarily if a beneficiary's well-being is at risk, such as in cases of substance abuse. However, trustees cannot withhold distributions arbitrarily unless explicitly authorized by the trust's terms or if the trust itself is discretionary. Failure to make timely and accurate distributions can lead to beneficiaries suing for breach of trust. Therefore, it's essential for trustees to handle this step of the process with care. How does a trust work when someone dies if it's not funded? If a trust is not funded, it means the grantor did not transfer property titles into the trust before passing away. If the grantor's intention to transfer these titles into the trust is unclear, the assets may need to be handled through formal probate. However, if the grantor's intent to transfer assets into the trust is evident, for example, it's mentioned in the trust instrument, you might be able to use a Hegstad petition, which is a type of 850 petition, to complete the transfer without going through probate. Simone Legal PC always drafts a special part of the estate plan called the Declaration of Trust that clearly announces, citing the Hegstad case, the intent for everything owned by the grantor to be included in the trust. It's all about intent. To use a Hegstad petition effectively, it's best to consult an experienced probate attorney. They can draft the petition and present your case to the court. If successful, this petition will be faster and much less expensive than a full-blown probate case. What happens to a family trust after death? Family trusts can be either revocable or irrevocable, just like any other trust. When we refer to a family trust, we're usually talking about a revocable living trust, which we discussed in detail earlier and in quite a few videos here at Simone Legal. These trusts are designed for the benefit of beneficiaries who are typically family members of the grantors, usually the children of the grantors. A family trust can include a wide range of assets, such as a family home and/or family business. After the grantor's death, the management of a family trust can vary. For instance, if the trust was set up jointly by a husband and wife, the surviving spouse may inherit full control of the trust assets or a portion of them. In some cases, the death of one spouse may trigger the creation of subtrusts to protect assets for children while providing financial support for the surviving spouse. When the surviving spouse dies or becomes incapacitated, the trust usually becomes irrevocable, and the process of trust administration for the first successor trustee, begins. So that's it. Thanks for tuning in to this video. If you enjoyed today's content and found it helpful, look around the website. Make sure to check out all our videos about estate planning, real estate law, and we are here to protect your family, you, and your assets, bottom line. Got any questions or topics you want us to cover? Drop them in the comments below. We'd love to hear from you. And if you're looking to buy, sell, or just need some advice on your real estate journey or estate planning, don't hesitate to reach out to stuartsimone.com for a free consultation. That's right, free. So until next time, thank you for watching, and we wish you all the best for you and your family at Simone Legal PC.